Hey everybody, John Skiba here, and in this video I'm going to answer the question of whether creditors are going to be able to go after that second round of stimulus checks that probably just hit your bank account. But if this is your first time here to my YouTube channel, go ahead and click subscribe, check on that little bell. That way you'll be notified each and every week when I provide new videos that'll help you deal with serious debt problems. All right, let's talk about the stimulus check and how that can impact your overall situation. Obviously the stimulus checks are awesome. They're great as far as helping us to pay for some of the necessities. A lot of people are using them to help get out of debt. Debt collectors know this as well. I think that's why I'm seeing a little more pushback these days on some of the settlements, because I think people have a little bit more money. But obviously I'm recording this video during the whole COVID-19 pandemic, and here in January 2021, these stimulus checks are starting to hit people's bank accounts. They've been sent out in the mail if you're getting them that way. And a question I'm getting from a lot of my clients is, can my creditors go after those? Or what about if I'm in a bankruptcy case? Can my bankruptcy trustee seize that check and send the money to my creditors? In most cases, it's going to be difficult for your creditors to get those stimulus funds. There's some exceptions to that though, and I want to talk about that. So, for most people, the stimulus checks are being deposited via direct deposit right into your checking account. You wake up and surprise, there's anywhere from $600 to a couple $1,000, depending on if you have kids and dependents, if you're married, all that kind of stuff. So you wake up and there's some money in your account, which is great because that can help it, particularly when things are difficult like they are now. However, what does that mean for your creditors? Can they go after that? Now, the good news is if the money's deposited into your checking account, unless your creditors have a judgment against you, it's highly unlikely they're going to be able to seize those funds. Creditors, particularly unsecured creditors like medical bills, credit cards, they have to sue you, get a judgment against you, and then in most states there is a garnishment procedure. Like here in Arizona where I practice, they file an application for a writ of garnishment, and they have to serve that on the bank to be able to freeze those funds. That takes time. They have to know that the money's in the account. But so if you don't have any judgments against you, if none of your creditors have sued you, then it's not something you need to worry about, because they're not going to be able to just come in and take those funds. However, if you know that there's an old default judgment out there or something that, from the past that is still kind of lurking out there, then I would recommend being really careful about leaving a lot of money in your checking account, because if the money's in there and they get rid of garnishment and they serve it, they're going to be able to tie up those funds unless there's some type of exemption in your state. Now, what's important to note is under the federal statute, there is no exemption that says that creditors can't take this. So if they have a judgment, if they get the bank levy, they garnish those funds, you're going to be out of luck. So what can you do? I mean, you can use the money. You can, obviously a lot of people need it just to cover their basic expenses right now if you spend it down, or if you take it out of the bank. It's something where you could keep it at your home and then use the funds for living expenses then. The only time you really need to be worried about that is if they already have a judgment against you, or if you're dealing with a lawsuit right now. It's probably not something where you want to have a lot of cash in your bank account. Now, what if you're in bankruptcy? I do bankruptcy here in Arizona, and that's a question I'm getting is, are the bankruptcy trustees going to take those funds and make a distribution to my creditors? Now, we got some guidance back in April of 2020 when the first round of stimulus checks came out. Because unfortunately, Congress, when they put the CARES Act together, they didn't put protections for these funds in the law for those people who are in a current either Chapter 7 or Chapter 13 bankruptcy. However, the United States Trustee's Office, whose job it is to oversee the bankruptcy process, they put out a statement back in April 7th of 2020, and they said a couple things. One, if you are trying to qualify to file for a Chapter 7, the CARES Act specifically does state that the stimulus funds will not be counted as part of your current monthly income as far as the means test. So you have to qualify to file a Chapter 7. You have to make at or below a certain amount of income depending on your household size and which state you live in. They said specifically in the statute, it says that that's not included in that. So it's not going to make it so you can't file Chapter 7 if that's something that you need to do. But where the law is silent is it doesn't offer any protections for these funds from the bankruptcy court and the bankruptcy process. However, the trustee, again, whose job is to actually take money and distribute it to creditors, here's what the statement says. They said, regardless of whether the stimulus check is property of the bankruptcy estate, the United States trustee expects that it's highly unlikely that the trustee would administer the payment after consideration of all relevant circumstances. So the trustee's office is having a heart. They have one. They have a heart, and they're saying, look, we know that this is a very unique time in history. These funds were sent out to help people cover just their basic living expenses. So it's, again, in their words, highly unlikely that they're going to go after those funds. And in fact, they even put in here that trustees that are thinking about doing this, thinking about going after them, they're directed to notify the United States trustee prior to taking any action in recovering stimulus checks or objecting to Chapter 13 plans based on the treatment of the recovery stimulus checks, those rebates. So again, this is from April of 2020, but I anticipate, because this seems to all be distributed under the same law, that we're still going to see that that's the case now, that in the bankruptcy court, they're not going to be seizing those. With that being said, I haven't heard anything in Arizona as far as the trustees saying, making a request for them or saying that they are going to administer them. In other states, you may have an exemption, like a wild card exemption that will protect them. But with the first round, I didn't see it impacted whatsoever. The funds were sent for people to be able to cover their basic expenses, and that's what the trustees were going to allow you to use them for. So I hope that helps. Hope you've got your stimulus check already, and I hope that that is helping you kind of weather some of this difficult time. The end of last year, the beginning of this year seems to be pretty rough, particularly here in Arizona. It seems to be pretty rough. But hopefully that helps you when it comes to questions about the stimulus check, that you can use those funds to help your family as you keep moving forward. So I appreciate you watching today. If you haven't subscribed already, please go ahead and click subscribe here to my YouTube channel. Again, appreciate you checking in today.